right, good morning. I'm so glad to see you all here. First and foremost, Keith and I are not here to sell you something. We're here to educate you. And then you go to see your financial advisor and your estate plan attorney, so you've got good questions, you know what to do. As Jim said, this is a moving target, the areas of law that we're going to talk about today. My part of the puzzle is the estate plan. A lot of people think, oh, I have to be Bill Gates to get an estate plan. I don't have that many assets. If you own more than your car and your clothes, you've got an estate. You've got a bank account, you've got real estate probably, you've got some investments, you may have some assets you've inherited from your parents or your siblings, your personal property, your collections. There's all kinds of things you have that have value that if you do not plan where they go, the state tells you where they go after you pass. We're not going to get into what the state says. The state does not take your assets. That's a common misconception. They do not take your assets. They tell, through the probate process, that's the court process of who gets your assets after you pass, the state law says where it goes. Okay, what is an estate plan? It's a bunch of documents, legal documents, that does several things. Part of it helps you if, God forbid, you are incapacitated, meaning you can't handle your finances or your health care decisions. Part of it directs, as we said, where it goes after you die. And, sorry, I'm in your way. And who's in charge. It protects you, your finances, it helps you with your health care. Big benefit to your family. That's probably the most important part. If you have adult children, or especially if your adult children are not sure of what your finances are or how to help you, get it in writing. Those are some of the things that an estate plan can do. The moving target here is the middle part, $12.9 million. Let me talk just a little bit about taxes, and our expert will go a whole lot more. We pay sales tax when we buy something. We pay income tax at the end of the year for what we've made. Estate tax, many times it's called death taxes. That's what we're talking about today, death taxes. That's not the real name. That's what most of us just think of it as. You can die owning $12.9 million in assets before death taxes or estate taxes click in. So most of us don't have that. If you do, we need to talk privately, because there's some planning we need to do there. But this law is in flux. In the end of 2025, I call this a coupon or an exemption amount. The end of 2025, this exemption goes away. The law sunsets. I don't know what we have after that. During my career, I've seen the estate tax exemption as low as $650,000. This is the highest it's ever been. So I can't tell you what's going to happen, but I can tell you need to plan in case the law sunsets and we don't have any exemption, which means all of your assets would be subject to death taxes or estate taxes after you die. Okay, probate. That's the court process of who gets your assets after you die and who is in charge. We used to call it executor. It's now called personal representative. Probate is completely avoidable with proper planning. There are all kinds of tools we've got to avoid probate. Again, the misconception is, well, if I have probate, the state will take my assets. No, they won't. The attorneys will. Yeah, I did say that out loud. So the legal fees on a probate are horribly expensive. The court costs on a probate are horribly expensive. We're doing probates now, and this is not about me saying specific dollars, but I just want you to have an idea. We're doing probates now between $8,000 and $10,000 on simple estates. That's a lot of money out of your estate if you do a little planning now to avoid probate. We're good? Yes, sir.
Lynn, what is the death tax today? If you have the exemption, fine. If not, in 5 years or whatever, 25. What is the typical death tax on a percentage?
This is Keith's wheelhouse, okay. So I'm going to defer. Do you want to answer now or wait till you're up? Okay. He's looking it up. He's got the book.
Isn't it close to 50% or something pretty high?
Last time I looked at it was 40%.
40%?
What Jim is asking is, what is the percentage, if we had no coupon, no exemption amount, how much does the IRS want to take of that? The last time I looked at, the upper level was 40%, but Keith's going to look it up exactly. We don't want this. We don't want this. It's avoidable. So, okay, any questions on probate, the legal process, and why we want to avoid it? Okay. What is subject to probate? And this gets into how do we avoid it? Well, if someone dies with assets in their name, and there's nobody else's name on it, and there's no beneficiary designation on it, and I use beneficiary designation, payable on death, transfer on death, all interchangeably, because it transfers when a person passes. So any asset in a person's name who died, only their name, and no beneficiary designation, that's probate, because the only way you can get it out of the deceased person's name is through the court process. What is the most common probate asset? Your house. You think about it. If you're married, it's in a married couple. One spouse passes, the other still owns it. Then when they both gone, it's probate. I got a tool for that. We'll get into it later. Okay, there's your house. Mr. Snowman, it's March, time to talk estate planning. Most of us don't think about estate planning until we're in the latter part of our lives, simply because when we're 20 years old, we think we'll live forever. This is a common theme. This is human nature. It's good that y'all are talking about it now and thinking about it now. Talk to your kids. If they're over 18, talk to your kids. It's important they have an estate plan too, but because it's not the tail end of their life, they're not going to think about it and they're not going to agree. Estate planning documents. What are the documents, the base level documents that I recommend every Floridian have? That would be these 4 documents. The durable power of attorney. Let me back up. The first 3 are if, God forbid, you become incapacitated, meaning you can't do your stuff. The last one is after you die. So the first 3, if you need help with finances, you name somebody you trust in your durable power of attorney to help you with finances. Now, this is not naming them to use their money to pay your bills. This is naming them to access your money to pay your bills. So it's got to be somebody you trust who's good with the finances. I want a primary, and I'm always going to recommend a secondary, because if the primary is not available, you don't have to come back to me to do it again. Healthcare surrogate, same sort of thoughts. Incapacitated, God forbid, need help with healthcare decisions. And this is why I brought up, get your kids an estate plan. These first 2 documents, your adult children should have, because if they're at college, you can't find out from the registrar how much tuition is due. They won't talk to you. They're adults. If you need, God forbid, they're in the hospital, you can't make their health care decisions. They're adults. So very, very important that your adult children have those documents. Living will. Your adult children cannot foresee needing this. This is end-of-life document. Most of 18 to 25-year-olds can't even wrap their mind around this. This is where a scenario of where person is incapacitated in one of 3 physical situations where it's end of life. They are already plugged into life support. That's the respiration, hydration, and nutrition. This has nothing to do with health care, with pain care. Pain is still addressed, such as under-the-tongue medication and other things that alleviate pain. This is the tubes that are keeping the person alive. So if you do not want to be kept alive in a terminal situation, meaning you're not going to get better, you may want to consider a living will. Don't talk to your adult kids about this. They can't wrap their heads around it. Last will and testament. Who gets your assets after you die? Who's in charge? Pretty straightforward. Many people think, oh, I have a will. It's not going to go through probate. This is the roadmap to the probate court who gets your assets. That is probate. So our job is to get your assets set up to avoid probate and have that will as the backup. I'll get more into that later. Okay, durable power of attorney, already covered that. That's for finances. We had a huge law change to power of attorney in 2011. If you've got one or you did a legal Zoom, it's time for an upgrade. I make lots of money, sounds very crude and I'm sorry, on legal Zoom documents where clients come to me with legal Zoom, they think they're protected. They're not. They're not Florida documents. So healthcare decisions, we want to set that up. We had a big law change to this in 2015. So if your healthcare surrogate designation is older than 2015, go see your estate plan attorney and say, I need an updated one under current law. My favorite cartoon in the world, I put this in every single presentation I do. If you can't see it at the back, Mama and Papa are sitting in their easy chair. Papa says, just so you know, I never want to live in a vegetative state dependent on some machine. If that ever happens, unplug me. Mama says, okay. Mama gets up and unplugs the TV. I love that cartoon. I just love it. David's seen it 50 times. Okay, living will, that's the end of life document. I kind of jumped ahead a little bit. I do want one warning on living wills. This is where you say, if I'm in this scenario, this scenario, this scenario, please, I've appointed this person to go talk to the hospital and say, let me go. Hospitals, I've had 2 different calls where my client had a living will, and Sharon, you know this, and the hospital were ready to remove because it's a legal document, and the family was standing saying, wait, we've got Aunt Sally to come in from California. We've got to pray. We've got to say goodbye. And the hospital went ahead and removed. So when you check into the hospital with your loved one, they want photo ID, they want insurance card, they want living will. Give them 2 out of 3 of them. Do not give them the living will. Do not give your doctors the living will because the doctor will fax it or email it to the hospital. We as Christians certainly want to honor God with life and everything associated with it. I have Christian texts that I can add to your living will. I also have Christian texts I can add to your last will and testament. It basically, I did not write it, I got it from a friend of mine. It basically says, I love Jesus, I hope you do, see ya. So, all right. It's a little bit more formal than that. All right, these are the 3 medical conditions that are listed on the living will. I only list this because there's great confusion over this in that some of you may remember the Terry Schiavo situation, the lady who had the severe brain injury and she was being kept alive on life support. And her parents wanted her left on life support. Her husband said no. And so there was a huge media circus. And we had hoped that our legislators, and I'm not getting into political stuff here, but we had hoped our legislators would further clarify what living will is and what it's not. This is the exact same law we have from when Terry Schiavo was in the bad situation. And because it was written by legislators and not medical professionals, it's not really, it's not helpful. I think the terminal condition, there's the definition, which to me looks just like end stage. My medical clients, if you have a medical background, you probably know the distinction. My medical clients, I'm always asking them, do you see a difference? Oh yeah, oh yeah. What is it? Well, they kind of give me examples which each one would be. The terminal condition was cancer. The end stage was Lou Gehrig's or Parkinson's. I have an attorney brain. That's not helpful to me. It doesn't really matter what I think this means. It's what you think. So if you could, God forbid, envision yourself in one of these scenarios, if you want life support removed, that's where you initial it, so that authorizes your agent to step in. If you want life support continued, remember comfort care is still provided, then you leave it blank. The easy one to me is persistent vegetative state. I can wrap my head around this one. The brain dead, the brain coma, the things we're not coming back from. Okay, living will, as I said, it's the 3 things. I get lots of questions about, well, I don't want to starve to death. I don't want to be thirsty. I've asked this question to many of my medical clients to say, do you agree on leaving in hydration and nutrition? They consistently say, and ask your doctor about this, they consistently say no. As we're in the dying process, our bodily functions are shutting down. And I know this is not a fun, it's going to get better after this, I promise. Our bodily functions are shutting down, and we can't process the nutrition and the hydration, and it swells the patient up. Robbie's in the background shaking her head, yes. So, but it's your choice. It's your choice. I have done many living wills where we've left the hydration in. Okay, spiritual preparation. This is one of my early examples of what we can drop into the living will. I actually have a better one now, that more I love Jesus stuff. But that kind of gives you an idea. You can get this in the PowerPoint. If you email me for the PowerPoint and you want my updated living will and last will and testament, I love Jesus, I'll email it to you so you can take it to your attorney. The good thing about putting these in your documents, lots of people see them that don't know Jesus, so it's a beautiful thing. Okay, Mama and Papa, I keep having nightmare that we don't spend the money and time and the kids inherit it all. My husband and I are in this right now. It's like we look at how hard we worked, and I don't want our kids to get all that, so we're just pitching it away, charities as much as we can. This is a real thing. If you've been careful with your money, and we were talking about it early, careful with your money and your assets that God's given you. You've been good stewards. This is something, plan for your charities. And this is not a blatant pitch for Belle Isle, but you should. Okay, last will and testament. Again, this is your roadmap to the probate court, who gets your assets and who's in charge. So this is probate, so it's not a probate avoidance. We'll get into that later. If you don't have the will, the state says who gets your stuff. And it's basically kind of defined by family and marriage and things like that. It may be who you want. It may not be. It may be who you want in charge. It may not be. Okay, this is how you avoid probate. We want to ensure your assets have beneficiary designations or are jointly titled with somebody you trust. You don't want to put your bad child on there on your bank account if you know your bad child's going to empty it out and run off to Vegas. Right of survivorship. This is more kind of deed language, which I'll circle back to. And then the monster for probate avoidance is the revocable trust or the revocable living trust or the living trust. They're all the same. Trust is like a basket. You put your assets in the basket, and that says who gets it. This avoids the probate court because the basket says who gets it. Okay, the big dividing point in estate planning is, do I do the will-based package or do I do the trust-based package? I get all kinds of people come into my office and I'm talking them out of a trust. I make more money if I do a trust and I talk them out of it, because if we can use all those other tools to avoid probate, why spend the money for the basket? So why would you have a trust? These are some of the reasons why you want a trust. Certainly minor children or minor grandchildren that you want to provide for. Just as an aside, if you leave a minor child an inheritance of greater than $15,000, then we have to go to court and establish court guardianship. And guardianships, like probate, is very, very expensive, and that eats their inheritance up. So if you set up a trust, we don't have to do court guardianship because the trust says how they get it, when, and how. A minor, by the way, in the state of Florida is 18, younger than 18. Okay, if you are supporting a long-term family member, a disabled, elderly, someone who is on your payroll and you're taking care of, trust is the great example for that, because you can do their support and the inheritance doesn't hit their hand. That's a key factor, because if it's a disabled person, not usually by age, but because of disability, they either have government benefits like Medicaid or food stamps or all kinds of host of. We do not want them to get an inheritance and get bumped off of government benefits. So that's a key important for trust. If there are children from a previous marriage, and unfortunately I now have to say, or relationship, this is part of what practice in law is now. So if there are children that are not part of your current family, a screaming trust would be what I would be doing in my office, simply because we're going to say, Mom and Pop, but they're all Mom's children. Mom dies, Pop may or may not take care of Mom's children. And so that's why you want to set up a trust. Family member with special needs, a disability, adult children still working on growing up. This could be, before I had it a little bit more unkind, so I changed it to that. The loser. The adult child who may have a substance abuse problem. The adult child who's a spender. The adult child who has a lawsuit chasing them, creditors chasing them. Or the biggie is the adult child about to get divorced. You don't want the divorcing spouse to take their inheritance, and it can happen. So we draft into our trust, we call it trustee discretion, so that the child that's still growing up, we put the person in charge, not them, the person in charge is the trustee, can withhold their inheritance until they get through the situation. And if they don't ever, then we use their assets to support them for counseling, for medical care, for a car, for whatever. It's important. Financial support of yourself, really important for you. If you want your assets protected and you have a specific idea, I want a new car every 5 years, we draft that in the trust for you. Assets that cannot be set up to avoid probate, and we'll circle back. If you can't name a payable on death or a beneficiary designation, or you can't do a specialized deed on your house, we may need to transfer that asset into the trust. Okay, types of trust, there are a whole slew of them. I'm not going to go into all of these, but this is definitely the upper level trust and estate planning. We do, like for land trust, you only do that if you want to keep it secret who owns the property, because you put dirt in there, real estate in there. Most of what we do are revocable trust, because that is more broadly what most people need. We do irrevocable trust if you have a taxable estate, if you're charitable minded, if you've got life insurance, big life insurance. So there's all kinds of things that we can do with trust, but most of them are the revocable living trust. I kind of went through this. It avoids probate. That's the biggie. And it's really important if your family dynamics or you've got somebody in there you need to support. Okay, living trust. There's your basket. We're dropping just about everything into it. We don't put your cars. We do put your RVs, your boats, your golf carts, things like that. I already mentioned the new laws for durable power of attorney, and I put this in here so if you pull the PowerPoint, go home and look at your durable power of attorney if it's older than 2011. You need an updated one. Our healthcare change. The biggest part of the healthcare law change on the healthcare surrogate is that for your surrogate to step in, two things have to happen. The doctor has to declare you incapacitated. Well, of course, nobody steps in if you've got your capacity. And the doctor has to put it in writing that you're incapacitated. And what we're seeing in practice is doctors, because they get sued by the dang lawyers all the time, that in practice the doctors are very, very slow of writing a letter of incapacity. So it ties up our families from helping us. So we've added a provision to our healthcare surrogates that we don't need that written determination. So discuss that with your, let me back up. Discuss that with your estate plan attorney. The last issue here, this is Keith's wheelhouse firmly. There are major law changes on IRAs, and I'm not even going to touch it other than you need to listen when he talks about that. That's all I've got. Let me bring up one other thing that I didn't, there's my email. Let me bring up one other thing that I did not put into the slides. Remember Lady Bird Johnson, President Johnson? They had scary, bright attorneys in Texas, and they created this legal maneuver called an enhanced Lady Bird deed. Lady Bird attorney, Lady Bird's attorneys, it's kind of like a deed naming a beneficiary in it. And remember I said probably the one asset that everybody's going to have subject to probate is their house. Years ago, we transferred our house to our trust that avoided probate. Yay. Then we had bad case law that says it's subject to lawsuits in a trust. So we all moved it out of trust. So if you've got an old trust with a house in it, your attorney was right then, but law changed. So now how we're solving the problem to make the house avoid probate without losing the creditor protection afforded by the Florida Constitution and your homestead exemption afforded by the state of Florida, the county, excuse me, is this ladybird deed. You keep all the rights to your house during your life. It's called a life estate, an enhanced life estate. And the remainder, if there is any, because during your life, if you sold it, it's gone, the remainder's gone. If you gift it away, the remainder's gone. If you've mortgaged the hilt out of it and there's no value, most of the remainder's gone. So if there's anything left, the remainder, if any, then goes to who you say. It can go to your trust. It can go to your kids. It can go to your brother. The beauty of this thing that it avoids probate is when the owners die, we record their death certificate, and it transfers by recording the death certificate, no probate. It's an amazing thing. So if you got any questions, I'll take them. If not, email me if you want the PowerPoint. Y'all have been a good audience. Thank you. Laughed at my jokes. Thank you.